not stop in any time. Emotion never hit my child. I have 7 children that I'm involved with every single day and raise, and even my other 3 that I don't get to see, that I still see them every weekend. But again, I'm not a violent person towards my kids. So
So Layla lied to the police?
I believe it was a lie. She's had issues with that in the past. She's 9, not with issues in this situation, but lying, and I think she was scared. I don't know, but I know that I never turned and I didn't put hands on my child.
The report says that she pushed you, trying to get you off of her mother, then you turned and punched her in the stomach, and she told the police that she had stomach pain after being punched by you.
I know that I did not turn and hit my child. I think that she was scared. I did not hit my child, Judge. I know that for a fact. She didn't push me. I was pulling her out the door. I had the door open, and she was hitting me in the side of my head and face, which I got that lip from it, but I did not ever stop at any point to hit my child. The investigation as well. She did that. She was lying through an investigator because she wanted me to be in trouble for her and her mother fighting. She felt that I needed to be in trouble for it.
So was Jessica lying when you said that you choked her out?
I don't think I choked her out, Judge. I did grab her, but I even told the officers as well. I did grab her by the neck and her coat that she had on and drug her out. I didn't choke her. Choking her, I don't know. But I did grab her by her neck and her jacket, the side of her arm, and yanked her and drug her out to the door.
The report says that you put 2 hands around her neck and choked her for about a minute.
I don't believe that to be true, Judge. I was drinking, like I said, but I don't. I just grabbed hold and pulled out, moved her out. I mean, I obviously maybe choked her while that was occurring, but I didn't choke her.
You dragged her out of her house like somebody would drag a dog out of the house. They need to go outside, right?
I don't think that sounds like a lovely way. Just pulled her outside.
Dragged her out like a dog. No? Okay. All right. Ms. Robinson, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
Your Honor, I'd like the court to consider that the 12-month cap was offered by our office. The recommendation from the agent was prison. People are sticking with that offer because of the statements we have had from the victim since. So I would ask the court to sentence pursuant to the offer that we made. However, I would ask the court to maximize the amount of time that he gets here so that when he's out, if he violates again, prison is all that is left. I think it is important to note that the minimization here leads me to believe that all of the work that is being done is simply for the purpose of looking good to the court and trying to avoid jail time. It doesn't actually seem to be anything genuine by the defendant. He just, every question minimized what happened. You know, he said he just took her outside. Ms. Frost indicated to the officer that when he dragged her outside, he body slammed her so hard onto the porch that she urinated herself. The fact that his daughter, who he claims was punching him, but he put no hands on, felt the need to intervene as he was attacking her mother. I find that to be problematic. We have heard from the victim. She has indicated that she wants all of this dropped. She doesn't remember it and makes a point of telling our office that she can't afford to live without the defendant, that he pays the bills. I believe that this is a family that is in a situation where the fact that he is the provider is leaving them in a state of needing to be controlled, even in the last 2 minutes where you questioned him. I know you heard this, but you asked him what kind of person chokes someone out. He said, oh, someone not in a good place who's drinking. And then later when you said you choked her, that's what it said. He said, why? I don't really think that happened. So I would ask the court to sentence pursuant to the offer that was made. We will dismiss the new charges as we said we would, but I would ask the court to consider all of that when deciding how much of this time you should serve and before making any decisions about the no contact order. Thank you, Your Honor.
One question for your,
Yes, Your Honor.
both of you. The 2024 domestic and district court here on the PSI, it shows it was pending with the sentencing date of March. Did he end up pleading to that? Was he sentenced to on the domestic district court?
I don't recall were you on probation? 6 months. Yeah, he thinks he may have been on probation on that one.
I did 6 months of probation for district.
6 months of probation
Okay.
in district.
And was the victim in that case Ms. Frost as well?
I believe she was. She's here today.
Your Honor,
Yes.
my notes indicate that there was a deferred sentence on the misdemeanor domestic violence in the district court here.
Okay. They successfully completed the deferral?
It appears so because he was discharged from probation successfully on September 26th of 2025, Your Honor.
All right, the PSI says he's got 90 days credit, rated 2 days on this file, originally 2 days, then sentenced to serve 87 days with 87 days credit, and he served 3 days for posting bond on this probation violation. Does that sound right, Mr. Watkins? You served 87 days in jail?
Yes, sir.
Judgment sentence says you served 45 days. You had 11 days credit, and you served 45 days. Over 45 days, 11 credit, you had 34 to serve.
Are you talking about the underlying charge, Judge?
Yeah,
Yeah, I think that, all right, so what had happened in that case, from what I recall, is that he bonded out, but probation thought he was still in jail while he bonded out, so that they had it 90 days
okay.
of him
So
serving
so
where
he
he,
served 45.
I think that's the number, Judge.
Okay, okay. That's what we had as a credit for 48. All right, the court recognizes that the advisory guidelines in this case would suggest a sentence between 0 and 11 months. The courts can exercise my discretion, sentence consistent with the advisory guidelines, consistent with the agreement in this case, would be the sentence of the court that this defendant served seven months in the Nuevo County Jail. I'll give him credit for the 48 days that he's served so far. Is going to be continued on probation with the same terms and conditions as was originally imposed. Mr. Watkins, the court probably would have given you the 11 months or a year, but you have been, say, I'll use the term generously, you've been working on some issues. I don't know if you've just been going through the motions or if you've been actually working on the issues, but at least you're trying. You got a long ways to go. You can tell from my court's questioning and dissatisfaction with your answers, you still haven't internalized what you did, I don't think. But you spent a fair amount of money, you've been trying to do the right thing, so that's the only reason that you're getting 7 months and not the year. You do have the right to make application for you to appeal your conviction sentence. If you're not a foreign attorney, the court appointed attorney to represent you on the appeal request for a lawyer must file the court within 42 days. You need to go to the
Judge, just for clarity, so is a no contact lifted with Jessica Frost? Because I think that was lifted with the original probation violation.
No contact. You choked her. No contact.
The courtroom drama surrounding Mr. Watkins was not just about a probation violation, it was a raw exposure of denial, power, and accountability. What began as a negotiated plea quickly evolved into a tense moral confrontation between the bench and the defendant. Watkins admitted to grabbing his fiancée, Jessica Frost, but resisted the most serious elements of the police report. His repeated minimization, "I don't think I choked her," stood in sharp contrast to the documented allegation that he placed both hands around her neck for nearly a minute. The most explosive moment came when the judge directly challenged his character, asking what kind of person commits such an act. Instead of full ownership, Watkins shifted blame to alcohol and emotional distress. When confronted with claims that he punched his daughter while she attempted to intervene, he flatly denied it, suggesting she fabricated the story out of fear or retaliation. This strategy backfired. The prosecution argued that his selective memory and soft admissions demonstrated image management rather than genuine reform. In a powerful analogy, the judge compared his actions to dragging someone like a dog out of a house, language that underscored the court's moral outrage. Ultimately, despite the sentencing guidelines recommending up to a year, the court imposed 7 months in jail, citing his rehabilitation efforts, but openly questioning their sincerity. Most tellingly, the judge refused to lift the no-contact order, emphasizing the gravity of choking as a form of domestic violence. This case illustrates a central courtroom truth: remorse without accountability rings hollow. Watkins' partial admissions may have reduced his sentence, but they did not restore the court's trust.